Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Stan Zlotov. Stan is a bankruptcy attorney, and his practice is located in San Jose, California. He received his AB degree in philosophy from UCLA in 1972, good old days, and his Juris Doctorate or law degree from Santa Clara University, 1976. He has practiced law since 1976 when he graduated. He was in a partnership as a consumer bankruptcy attorney from 1978 through 2000 and has been on his own as a professional corporation since 2000. Stan is a state bar certified specialist in bankruptcy, a past chairperson of the Santa Clara County Chapter 13 Committee, and he received an award in 2004 from the San Jose Consumer Bar for bankruptcy appellate advocacy, and speaks on consumer bankruptcy for the Bay Area Bankruptcy Forum. So Stan, thank you for being my guest today.
My pleasure.
Okay, so today Stan and I are going to be talking about what you should know about bankruptcy, and we're going to be focusing on bankruptcy for individuals. And so before we get started, I'll say Stan earned that degree in law and a specialization in bankruptcy for a reason. There was a lot of study, it took a lot of time, and so just understand we're just going to be scratching the surface on this topic as an introduction. This is intended as part of a continuing conversation that you'll have with a qualified attorney. Okay, so off we go. Stan, you've been a bankruptcy attorney for over 30 years, 33 years. Is bankruptcy different today from in the past?
It's different because the times are different, and but you know, bankruptcy is kind of a barometer for what's happening in the economy, and so as you might expect, you're seeing a lot of real estate related cases.
Mm-hmm.
You're seeing individuals who used to make big incomes that are not making that kind of money anymore, but are left with
big bills.
Big bills, exactly. The high living is no longer, and they're kind of sifting through what's left. So yes, those are kinds of changes that I've seen.
All right. So maybe you can elaborate a little bit more about these changes and of what's happened here.
Well, you know, for as long as I have been practicing for the consumer bankruptcy, I don't ever remember where there were so many houses underwater.
Yeah.
In other words, where the value of the house was less than the amount owed on it. And now over the last several years, there's almost been a constant stream of that. In one way or another, either it's the homeowner or the investor, the real estate investor, or a combination homeowner who thought to pick up a couple of extra houses in Las Vegas or Arizona or the Central Valley as well. And now that everything's collapsed, they're having debt issues and trying to figure out how to sort through the pieces, how to keep something, how to let it go gracefully. And so bankruptcy is something that, you know, these people especially need to become acquainted with, because it may help them. It's certainly a possible strategy that they might want to use. And then of course, the people that used to have high incomes, you know, some of them are taking longer to get back to work than in the past. So the market has not come back as quickly to full flush as people were hoping it would. And so that lingering unemployment or downsizing is creating tensions as well.
Yeah.
So.
Okay. Well, what are some warning signs that you should be considering consulting with a bankruptcy attorney?
Yeah, you know, I've always felt that bankruptcy is a last resort, and so it's something that, to me, you kind of feel it in your gut when it's happening. So, you know, obviously, if you're suffering a wage garnishment, if your house is close to being sold at foreclosure sale, these are clear warning bells. But even before that, since foreclosure takes so long, I mean, probably you should be giving yourself a period of time so that if you've missed your house payment for a number of months that started into foreclosure, and you say to yourself, well, I'm going to give it the extra college try to get that extra job, or to see if I can figure out some other way to make some money, and it doesn't happen, that's telling you that you probably should at least talk with somebody about the option of a bankruptcy. Similarly, if you're to the point of having no income or not sufficient income to meet your expenses, to where you're actually thinking of borrowing more, getting deeper in debt, or what I think is the worst of the situations that I have seen, where you're going to try to convince relatives to lend you money or friends to lend you money, then I think you need to also have that chat about the bankruptcy. Swallow your pride a little bit. You certainly don't want, I mean, the worst situation, I think, the most terrible situations I've seen are where people have dragged down friends and relatives into their financial quagmire as well. So, you have to know when enough is enough, and to try to staunch the bad.
Okay. So why does it make sense to see a bankruptcy attorney early?
Well, because there are some things that make a lot of sense in the world between people, debtors and creditors, that in a bankruptcy context can cause you problems. For example, you may owe relatives for money that they've advanced to you, and most often I see that people, when they do get some money back, like a tax refund, for example, or they get their first job, or their first bonus after having been unemployed for a while, they want to repay the relative. That's common sense.
Sure.
It's intuitive. It's perfectly ethical, except in a bankruptcy context, it triggers problems, because in a bankruptcy context, all creditors are supposed to be treated on par, and a relative is considered just the same as any other creditor. And so that could lead to the bankruptcy powers actually suing or demanding that the relative repay the money if it's been paid within a year of bankruptcy. That's one instance.
That's pretty painful, isn't it?
That's painful, and it's counterintuitive.
Ouch.
Yeah, and another instance would be, in bankruptcy, you want to try to protect what you have, and so there are timing issues, so that, for example, the amount that you can protect in, for example, an IRA may be greater, I think, on April 14th or 15th than it might be on April 16th. You may have greater ability to fund an IRA for last year and the present year, whereas after April 15th, it's just the current year, as I understand it. So. There are timing issues for trying to maximize what assets you can protect.
I see, okay. So what are the different bankruptcy chapters that apply for individuals, and some of the advantages and disadvantages of them?
There are actually three they're called chapters. The common one is Chapter 7, that's regular bankruptcy. And there's another one called Chapter 13 that individuals often utilize. That's commonly known as a repayment plan, Chapter 13, or small business or personal reorganization. And then there's Chapter 11, which is a bigger, more complicated type of reorganization that individuals can use as well. The Chapter 7 is designed for, I'd say, straightforward cases. So if a person, let's say, has been laid off for a while and they had to resort to credit cards, or they got injured and without proper insurance coverage, and so there are medical bills out there, and they still are without income or without much income, these people would be prime candidates for a Chapter 7 bankruptcy. So it's quick. The reason to do it is because it's quick. you file it and you get a discharge of your bills within three to 4 months. And if the debts were honestly incurred, you're done with it. Mm-hmm. The Chapter 13 is normally done by individuals who for one reason or another can't do the Chapter 7. So they can't do it either because they have too many assets or assets that may end up being taken from them and sold by a bankruptcy trustee in a Chapter 7, and they want to protect it. Mm-hmm. And in a Chapter 13, you can protect assets. Mm-hmm. Or you have mostly the kind of debts that they can't get discharged in Chapter 7. For example, most tax debts you can't discharge. Mm-hmm. Or they have, in the old days when people actually had houses they wanted to keep, the classic Chapter 13 would enable them to stop a foreclosure, resume the mortgage payment if they just had a temporary problem of income from a layoff, and then they could resume their mortgage payment and propose a cure for the back payments. So that would be a normal reason for a Chapter 13. And then the Chapter 11 is really only there for people who don't qualify for Chapter 13. So Chapter 13 is for small-scale reorganization, so your debts, your what we call secured debts, mortgage-type debts have to be less than $1.1 million, and the other kind of debt has to be less than about $360,000. So if you're over those limits and you don't want to do a Chapter 7 bankruptcy, or you can't, or you don't want to risk losing property, then your only other remedy would be the Chapter 11, which is much more complicated.
Okay. So is Chapter 7 like the most common, most popular?
Yeah, I would say that probably in this area, it used to be 70%, probably still is, I would say 70% of the cases are Chapter 7. Maybe 25% would be the Chapter 13, and then the rest would be the Chapter 11. Mm-hmm. So Chapter 7 is what most people opt for, yes.
Okay. I heard that the bankruptcy rules were changed back in 2005 to protect the credit card companies. So how were the rules changed, and how does that affect an individual's eligibility for bankruptcy protection? Well,
so what was enacted in 2005 is an income test. And so what happens is that the gross income you've earned for the 6 months prior to bankruptcy is averaged, and then that's annualized and measured against a federal standard. Mm-hmm. So for example, for a household of one, I think the federal standard is $48,000. For a household of four, it's a little under $80,000. So if you fall under those amounts annualized, then you qualify for Chapter 7, at least based on the income test. If you're over those amounts, then you have to have your expenses what's called means tested. And that means that the amount you're entitled to credit against your gross income is measured against what are essentially internal revenue standards that the IRS uses for collection. And so then you just kind of net out, based on those allowances, what's left. And essentially, if what is left is a surplus of roughly $200 or more, then you're disqualified from Chapter 7. And so that would be a reason why you would opt for Chapter 13, is because otherwise, if you decided to move ahead and file notwithstanding that surplus of more than $200, then you would be filing under what's called a presumption of abuse. And what that means is that the policing forces of the bankruptcy court, the U.S. trustee, would move to dismiss your case or require that you change it to a Chapter 13 or Chapter 11.